Good morning, everyone, and welcome to the second workshop on day 4 of Qatar National Product Week. For this presentation, we're going to be discussing the Qatar Tender Law number 24 of 2015 and its executive regulations, presented by Mr. Muhammad, Fؤاد, Managing Associate, and Mr. Rيبال, فتال, Senior Associate of Sultan, العبد and Partners Law Firm in Qatar. Welcome, Muhammad and Ribal. As always, the session will be 45 minutes. We start with the presentation, followed by Q&A. If you have questions, you can type them in the Q&A tab in the bottom of the screen, and both our presenters will be glad to answer any questions you have. Thank you, and I leave the microphone and the camera to you, Muhammad and Ribal.
Thank you, Aziz, and hello, everyone. I would like to thank you all for devoting your time for joining this online webinar. My name is Ribal فتال, and I'm a Senior Associate at Sultan, العبد and Partners. I'm jointly conducting this presentation here today with my colleague, Muhammad Fؤاد, who is a Managing Associate in the same firm. So, as you may already know, the focus of this webinar is on the tender laws and legislation in Qatar. For the sake of clarity and ease of reference, we will be showing a PowerPoint presentation that we have prepared and which we will go through while we speak. So, as you may see, the tender scene in Qatar is mainly governed by two specific legislations. The first main legislation is Law number 24 of 2015 as amended, which I will refer to while I speak as the tender law. And the subsequent legislation is the Council of Ministers decision number 16 of 2019, which I will refer to while I speak as the executive regulations. During this webinar, we will touch on 5 broad themes of the tender law, and they are as follows. First, the applicability of the tender law. Second, the procurement methods and terms provided for under the tender law. Third, tenders and bids committee and the government procurement regulatory department. Fourth, the award and execution of the contracts. And finally, fifth, applicable law and dispute resolution mechanisms. I will be covering the first 2 themes or topics, whereas my colleague Fؤاد will be covering the remaining topics of the presentation. However, and before starting with the first topic, I would like to list the key principles that tenders must be based upon, and which are justice, publicity, equality, equal opportunities, free competition, transparency, and value for money. Value for money means an assessment conducted by the relevant bids committee between the value or revenue expected to be obtained from the items, works, or services required, and the price borne by the relevant governmental entity. My colleague Fؤاد will be explaining later about the bids committee. Further to the mentioning of the key principles of the tendering process, I would also like to point out the object of tenders and subsequently the contracts that the governmental entities enter into, and which are as follows. 1, for the procurement of items. What is meant by items is all material, commodities, equipment, machinery, and other goods and supplies, and the like. 2, for the procurement of contracting works. Contracting works means construction and building works, and other engineering contracting, installations, manufacturing, operation, maintenance, repair, and the like. And 3, for the procurement of services. What is meant by services is technical, training, and consultative activities, lease of equipment and machinery, services involving cleaning, insurance, guarding, transport, and the like. Now, starting with the first main topic of our presentation, which is the applicability of the tender law. It is prudent to mention that the tender law principally applies to procurement of items, contracting works, services required by the following entities, which are ministries, governmental bodies, public authorities, public institutions, and according to a Council of Ministers decision, based on the suggestion of the Minister of Finance, entities whose budget is financed entirely or partially by the state of Qatar. As for the public entities that are explicitly excluded from the tender law, the tender law specifies the entities that fall outside its scope, and they are the armed forces, the police, all military entities. For these three, I mean the armed forces, the police, and military entities, the tender law does not apply so long the contracts they wish to enter into are of a confidential nature. Moving on, explicitly excluded from the tender law is Qatar Energy, which is previously named Qatar Petroleum QP, also Qatar Investment Authority, and entities excluded by virtue of a Council of Ministers decision. The tender law states that entities to which it applies must implement the provisions stipulated in the tender law when each governmental authority wishes to enter into a contract, especially if the contract is being or will be entered into with a third-party private entity, for example, a private limited liability company. Now, as you may see on the screen, and moving on to the next aspect of the presentation, I will talk briefly about the procurement methods and terms stipulated under the tender law. In summary, the principal method of procurement by a governmental authority is by way of open tendering. What this means is that the relevant department in charge of tenders and bids in the relevant governmental authority, for example, ministry, will announce the public tender on the state procurement website. As you can see on the screen now. So you should expect to find all the details in relation to submitting the desired bids for the tender once published on the said website. However, contracting for procurement by way of open tendering is not the only method the governmental authorities use for procurement. The tender law specifies certain means of procurement, and hence contracting as exceptions to the public tendering. These exceptional procurement and contracting methods may also be allowed by virtue of a decision issued by the competent minister of the relevant governmental authority or the competent chairman of any other relevant public body. The exceptional types of procurement by governmental authorities are as follows, as you may see on the screen: two-stage tendering, restricted tendering, procurement by negotiation, which is in Arabic mumarasa, procurement by competition, which is in Arabic musabaka, and finally by direct agreement. If I could explain each of these exceptions in turn very briefly, I would say the two-stage tendering is conducted where it is impossible for the governmental entity to estimate fees and prepare detailed technical specifications for the object of procurement, and in order to reach solutions that mostly meet the needs of the relevant governmental entity. In the first stage, the governmental authority will announce the request for initial proposals without specifying any prices, but it will include the technical proposals of the items, contracting works, or services to be procured. The tender documents will be delivered without payment of any fees at the first stage. After evaluating the initial proposals received by the bidders, the governmental authority will prepare the final tender documents and will send the invitation for tender to the bidders whose initial proposals were accepted to submit their final technical and financial proposals. The restricted tendering is conducted where the object of procurement requires invitation to specific suppliers, contractors, service providers, consultants and technicians and the like, and those who are registered in a list prepared by the relevant governmental entity for such purposes. As for procurement by negotiation, it is conducted in urgent cases and matters where the launching of public tendering is inapplicable. And in the event, the bids submitted in relation to a public tender are unacceptable, and there is an urgent need that prevents the governmental authority to undertake another public tender. A minimum of 3 companies must be invited to such a bid. Further, procurement by competition is considered for conducting studies or preparing designs, plans, models, and other technical works necessary for a certain specific type of project. Finally, the direct agreement, which is also similar to the procurement by negotiation method, is conducted in urgent and emergency cases, where public tendering procedures or procurement by negotiation are inapplicable, or due to the nature of the object or subject of procurement. To clarify, what is meant by an urgent case is any case involving the completion of the works, provision of services or items in a short time that is considered significant and essential to ensure the safety and efficiency of the functioning of the relevant governmental authority. And what is meant by an emergency case is any unexpected serious threat to the safety or security or any gross violation which stands as a warning against the loss of human lives, property or production, or the occurrence of environmental pollution, or any circumstance that affects the position of the state or a governmental entity, and which may not be handled according to the ordinary tendering procedures. It should be noted that all methods of procurement and contracting are mainly governed by the same provisions of the law and should comply with the same tender principles which I previously mentioned. Now, turning briefly to the financial aspects of the bidding or a tender, the executive regulations, which I previously mentioned in the first slide, states that every bid must be submitted with a bid bond. The bid bond amount should not exceed 5% of the estimated total value of the tender. The bid bond must be unconditional, fully payable, and irrevocable by the bidder. Where the bidder fails to submit a bid bond, the bidder will be excluded from the tender process. The bid bond must be submitted in the name of the relevant governmental authority that is being contracted in the form of a cashier's check or a letter of bank guarantee, which must be issued by a local or accredited bank. What we mean by an accredited bank is a bank accredited by the Qatar Central Bank. This bid bond is considered as a security for the contracting governmental authority, and it must be valid for not less than 120 days from the date set for the submission of the bid. Where the bidder is unsuccessful, the bid bond will be returned to the bidder within 7 days from the date of rejection. Similarly, the successful and awarded bidder will have to provide a performance bond, which must not be less than 10% of the total contract value awarded. This is to be deposited by way of a bank guarantee, also issued by a local or accredited bank. The performance bond, similarly to the bid bond, must be unconditional, fully payable, as well as irrevocable by the awarded bidder. The relevant department in the governmental authority will ask the successful bidder to submit the performance bond within 15 working days from the day of notification of the award. The successful bidder will be returned the bid bond within 7 working days from the date when the relevant governmental authority collects or receives from the awarded bidder the performance bond. Please note that the successful bidder will be deemed to have withdrawn from the bid if he fails to submit the performance bond and sign the contract within the period specified by the relevant governmental entity. I also note that an advance payment of a maximum 20% of the total contract value may be disbursed to the awarded bidder, but subject to the submission of an unconditional bank guarantee from a local or an accredited bank equivalent to the amount of the advance payment. and provided that this guarantee remains valid until the settlement of the full amount of the payment by deducting it from the bidder's entitlements or in handing over the works executed by the bidder. More importantly, and this is a very interesting point, the tender law explicitly provides that the chairman of the relevant governmental authority may exempt small and medium-sized enterprises totally or partially from the submission of bid bonds, performance bonds, as well as the advance payment guarantee, where the Qatar Development Bank has given a commitment or an undertaking on their behalf. Some of other general matters that you should keep in mind is that the bidder needs to comply with the conditions set out in the tender set of documents or the documentation. Also, the bidder must not revise the tender documentation, and that the bid will not be accepted if it does not include a fixed lump sum price. Of course, there are exceptions for including a lump sum price for performing a tender contract. And I mention as an example, if the contract is a framework contract. In cases of recurrent purchase of items, contracting works or services, or where it is impossible to determine in advance the quantity or the volume of the requested items, contracting works or services, the relevant governmental authority may, after consulting the competent department, enter into framework contracts. Framework contracts are concluded by open public tenders or procurement by negotiation, which is in Arabic, mumarasa, or direct agreements. The framework contracts must specify the prices of the items, contracting works or services within a particular period, pursuant to the controls set out by the relevant governmental authority. The framework contract is defined under the executive regulations as an agreement whereby the contracting party supplies the items, executes the works, or provides the services, subject matter of the contract, upon the request of the relevant governmental authority at the same prices set out in the contract throughout its validity period. Lastly, the submission of the bid will be deemed as an acknowledgement by the bidder that he has reviewed and approved all the tender documentation and is aware of all matters pertaining to the same and the purpose of the procurement by the governmental authority and why the governmental authority has pitched for such a bid. With that, I would like to thank you again for your time and conclude my part of the presentation. I will now pass on to my colleague Fouad, who will discuss the remaining topics. So Fouad, if I may say, the screen is yours.
Thank you, Ribal. And good morning, everyone. As my colleague Ribal introduced me, my name is Muhammad Fouad, and I am a managing associate at Sultan and Partners. I will be taking you through three main talking points. The first point is regarding the main key players in the tender process, namely the Tenders and Bids Committee, I will refer to as the committee, and the Government Procurement Regulatory Department, I will refer to as the department. The second point I'm addressing today is the award and execution of the contract. Third point is the governing law and the disputes that might arise between the awarded contractor and the governmental authority and the dispute resolution mechanism. The first point is in relation to the committee and the department. As I said, these are the two main players in the tender process. I will briefly summarize their parts in the tender process. Starting with the committee, the law provides that every governmental authority must have a tender committee, which will be responsible for conducting tenders in accordance with the provisions of the tender law. The members of the committee are generally employees of the governmental entity issuing the tender, although outside experts can also be members. The law assigns many rules to the committee. Importantly, its rule to receive and open submissions from the bidders. This should take place in a formal meeting, and minutes has to be taken to record the proceedings. It also makes the final decision on awarding the tender. For purpose of supervision of the works of the committee, 2 members from the State Audit Bureau and the department must attend the committee's meetings. However, your bids will be evaluated by the department and other relevant department within the governmental authority. I will talk now about evaluating the bids and the contract in the presentation. Next slide. The Government Procurement Regulatory Authority Department, which I will refer to as the department. This department is affiliated to the Ministry of Finance. The tender law grants the department the authority to establish classifications and assign potential bidders into these classifications after evaluation of the potential bidders' financial capacity, experience, competence, and previous works. The department also sets the criteria for evaluating the contractor after the performance of the work. This is why it is very important to keep good relation with the department. Potential bidders and service providers would apply if they meet the criteria to be classified, and the department will issue a classification certificate. Depending on the nature and the complexity of the scope of the work, a tenderer may be required to have a particular classification in order to participate in a specific tender. To apply to be classified, this of course will be before the participating in any tender. You would need to apply to be classified by the department, and you may submit your applications through المناقصات, which is the unified website of state procurement. Also, this website is affiliated to the Ministry of Finance, as shown on the screen. Now speaks about the award of the contract. The graph shown on the slide shows the decision-making process. Firstly, the committee will receive the bids. Then it will make its decision on awarding the tender. The procurement department and other relevant departments within the governmental authority will raise the recommendations to the committee regarding the winning bidder. The final decision is made by the committee and must be approved by the chairman of the governmental authority. The concerned department announces the winning bidder and notifies the other bidders of the committee's decision and the reasons for rejection for unsuccessful bidders. Winning bids are also announced on the المناقصات website. Now, after the award of the contract contains references to the specifications which will need to be signed by the parties. The contractor must adhere to the conditions of the contract and perform the scope of the work within the specified time frame specified in the contract. In case of any delay in performing the scope of the work, the governmental authority will have the right to impose a delay penalty, and if the contractor demonstrates that the delay was beyond its control, the relevant minister may exempt the contractor from such penalty. If you do not fulfill your obligations under the contract, the governmental authority would first serve you a notice describing the breach and requesting a remedy of such breach. If you also fail to remedy such breach, the governmental authority will be entitled to either terminate the contract or to appoint another contractor under the same conditions at your expense. So it is important also to note that since the contracts with the government authorities are mostly to serve the public interest, the law provides the governmental authority with the authority to terminate the contract if such termination will be in the public interest. Lastly, we must highlight that the tender law provides the governmental authority the authority to make changes, variation orders to the quantities specified in the contract or the term of the contract, or to reduce or to add items provided that it doesn't exceed 20% more or less of the original quantity of the term. However, the issuance of the variation order is subject to 4 conditions. Importantly, the first one is that it's not possible to issue a new tender for reasons of public interest in case of the variation by addition to the original scope of the work. Secondly, the necessary funds are available within the governmental authority in case of the variation, of course, is to add more scope of the work. Thirdly, the variation is issued during the performance of the contract prior to the start of any maintenance period. Exceptionally, the contractor may approve that the relevant minister issue a variation order during the maintenance contract. The variation is necessary and it was unforeseen at the time of preparing the conditions and specifications of the original tender. These are the main conditions required to be fulfilled to issue any variation order. So now we are speaking about the governing law and the dispute resolution mechanism. Generally, the government authorities uses template contracts in which the governing law clause stipulates that the contract will be governed by the laws of Qatar. Although theoretically, you may agree on foreign law, but this doesn't happen because these contracts are not negotiable. When it comes to disputes, distinction between disputes that might arise before awarding the contract and the disputes that might arise after the awarding of the contract. Firstly, the disputes which might arise during the bidding stage. The bidder, in this case, will need to file a claim to the dispute settlement committee. This committee operates under the Ministry of Finance and consists of a judge and 2 professional members. The bidder shall submit his claim within 30 days from the date of the occurrence of the disputed action by the governmental authority. The dispute settlement committee will hear the claim and must issue its decision within 2 months at the last. In the second case, where the disputes arises after awarding the contract, the parties in this case will resort to the civil and commercial courts of Qatar to decide on the dispute. If the awarded contract is considered as administrative contract, then it will be heard by special circuit within the court dedicated to hearing disputes arising out of the contracts that qualified as administrative disputes. To be considered as an administrative contract, the contract must fulfill the following criteria. Firstly, one of the parties is a public entity. Secondly, which is first, this condition is fulfilled in all contracts under the tender law. The second and most important condition is that the subject or the object is to serve public facility or public interest. Thirdly, The administrative contract must include clauses that are unusual in comparison to what is customary in the civil code. Another means of settling the dispute with the governmental authority is through arbitration. Very briefly, arbitration is an alternative way of settling disputes in which a single arbitrator or a panel of arbitrators are nominated by the parties to hear the dispute. Arbitrators are not judges, but the rule is parallel to the role of the judges in the sense that they will decide an award which will be binding on the parties. So if the parties wish to resort to arbitration instead of the courts of Qatar, the government entity will have to obtain an approval of the Prime Minister to do so. And with this, we conclude our presentation. Thank you all for your time and hope this gave you helpful insight to the tender law, and we can take questions and answers.
Thank you to our speakers today, Mr. Muhammad, Fouad, and Ribal فتال. And we already have questions, so let's get into it. The first question is from Munira al-Muhannadi, and Munira is asking, can you please explain again the term procurement by competition, مسابقة?
Yeah, of course, Aziz. So thank you for your question. As I mentioned, procurement by مسابقة is procurement by competition, whereby when the relevant governmental authority requires or invites certain bidders, or the bidders submit tenders and proposal whereby they will all conduct certain studies or prepare certain designs and plans or models for a specific project that the governmental authority is not determined on its specification per se. So it will make it's like a competition between all the bidders, and after that it will decide which one it wants to award the bid and proceed with its design or technical specifications or etc. Mainly it's like a competition between the bidders, and the governmental authority will decide which one is best for its interests.
Aziz, if I may add to Ribal, I can give an example. Like if the government of Qatar wants to open a new museum, and they might want to see which is the best design for the museum, so they might contract through this competition, and every bidder will submit a design, and then the committee will select the best design for the museum, and then they will announce the successful bidder which has submitted the best design for the museum. So in this case, the provision related to performance bond will not apply, because you will just submit the design to the committee, and the committee will select the best design for the museum. This is an example for where the contracting by competition may occur.
Thank you. Is that clear, Munira? Do you have any more question in that regard?
Let us see.
Okay. There's another question from Thomas Jose, who's asking, how can SMEs avoid or be exempted from bid bonds or tender bonds?
Thank you, Thomas, for your question. Well, actually, there is, as mentioned, there is an explicit article, which is Article 14 of the law, whereby the governmental authority may exempt SMEs totally or partially. It's at its sole discretion, of course, from the submission of not only bid bonds but also performance bonds during or throughout the validity of the contract, as well as the advance payment guarantee, where the QDB, Qatar Development Bank, has given a commitment or an undertaking on their behalf to the relevant governmental authority. I hope this answers that question.
Yeah, so just to clarify, this exemption or this rule might apply only to SMEs that are part of UDB's finance.
Correct, Aziz, 100%.
Clear. We have another question from Aisha Al-Ka'bi, who's asking, I think, what if the organization is semi-governmental? Will its contracts be administrative?
Yes, I understand that question, Aziz. Well, the law mentions that based on the Council of Ministers' decision, whether the entity is funded partially or entirely by the state of Qatar, it needs a decision to be considered as a public entity which the tender law will apply thereto.
Okay, thank you. Munira is asking, so thank you for your clarification on procurement of competition. And in that case, are tender bonds and performance bonds required in case of musabaqa?
No, it will not be required as under Article 7 of the tender law. In case of tender by competition, the performance bond will not be applicable in this case for the obvious reasons that the tenders will submit their designs and then they will be reviewed and examined by the committee, and then they will select the best design or according to the type of the
and will there be a commercial proposal in these in the competitions, or just technical in this?
It's really in most of the cases it is in relation to artistic works. So usually it's related to some special nature project that requires some designs or plans to be submitted first. And then it has to be selected before awarding the contract. It might, of course, include some commercial terms, but usually the technical specification, which will be the determining factor for selecting the bidder.
Okay, thank you very much. Muhammad Amran Sheikh is asking, where can we view the tenders issued by various authorities? So is there like a hub or a web page where all tenders are published? And also, can we have the soft copy of this presentation?
Yes, sure, Aziz. They will be published on munaqasat.ministryofinance.gov.qa.
Okay.
And also, when you got the specification, a certificate that I explained that you need to be classified first before participating in public tenders, and then you will receive like SMS for any new tender. So if you are interested, you might submit your tender through the Munaqasat website.
Great. And can we get a copy of the presentation?
Of course, it will be sent to you very soon.
Awesome. That's very helpful of you. Do we have any more questions? Guys, it's a very, very valuable opportunity to have two senior lawyers with us today. So let's make the best out of it. And I think the presentation was very well put together, and it explained what is, I think, a very complex topic in a straightforward and simple way. So that is very helpful. Thank you very much.
Thank you, Aziz. Thank you very much.
Thank you all.
Thank you all.
So it doesn't seem that we have any more questions, except thanks from everybody. So I will say thank you to our speakers again, Mr. Muhammad Fؤاد and Mr. Ribal فتال from Sultan, العبد and Partners Law Firm in Qatar for their valuable presentation and time today. And I look forward to seeing our audience in the coming workshop at 1 o'clock. Thank you,
Thank you
gentlemen.
so
and have a
much.
good
Wishing
day.
you best of luck. Thank you.
Have a good day.